Welcome, everybody. Today, I am really glad that we have Kelly Koch with us. She's with Compliancy Group. And today we're going to cover how is it that you ensure that your business associate that you're using is actually complying with HIPAA law. So when you decide on using a vendor for technology, such as a practice management program, EMR, EHR, video conferencing, secure chat, secure text, secure messaging, anything like that, how it is that you actually make sure that they're complying with HIPAA. So Kelly Koch has over 25 years of customer service experience, including a background in retail banking and accounting. She's currently the account manager for Compliancy Group, where she advises healthcare decision makers and medical vendors on HIPAA compliance. She effectively communicates the government regulation and necessary standards of HIPAA and how Compliancy Group can help simplify the process. In her spare time, Kelly is actively involved in the nonprofit organization Pull Through Network, which raises awareness and education for children and families who are affected by ARM, IA, and vectoral syndrome and other birth defects. Compliancy Group's web-based compliance solution, which is called the Guard, helps businesses address HIPAA compliance with guided ongoing support. The Guard is a trusted HIPAA compliance tool and has helped thousands of clients achieve, illustrate, and maintain compliance with confidence. And I can say that as one of their customers. I really appreciated the process that they did for me, walking me for my private practice through the process of HIPAA compliance. So Kelly, thank you so much for being with us today. We definitely have a lot to cover, and yeah, clinicians and administrators will find this very helpful because it could be a confusing process. If it's not something that someone does every day, it could be difficult. So just understanding what this regulation is. So for those of you that might be new to this, HIPAA is federal law regarding the privacy and security of healthcare information in our country. And those that are regulated by HIPAA law are called covered entities. Pretty much healthcare organizations, individuals that conduct electronic transactions with insurance companies or clearinghouses are covered entities, and also insurance companies and clearinghouses themselves are covered entities. And one of the requirements of HIPAA is that covered entities, say a healthcare provider who uses a vendor, say a technology company, to provide services for their healthcare company. And if that vendor has access to patient information, protected health information specifically, then that covered entity needs to get a business associate agreement from that vendor. So that's just to put out the framework of what we're looking at here. Now, the reason for that is HIPAA really helps ensure the privacy and security of patient information. And by covered entities complying with HIPAA, they do a really good job of that. But if they're going to use a vendor, a technology company that's not a healthcare provider, not regulated by HIPAA necessarily, the business associate agreement binds them to that law, makes them legally have to comply with HIPAA just like the covered entity does. However, it's not good enough to just get a business associate agreement from a vendor. You also have to vet them out to ensure that they, with reasonable effort, that they actually are complying with HIPAA. So Kelly, can you kind of explain a little bit, what is that requirement of vetting out the vendor and what's required there?
Absolutely right. And you hit the nail on the head with the CEs, covered entities. So those are your doctors, your hospitals, providers, clearinghouses. In layman's terms, those are people that deal with direct PHI, protected health information. So they're dealing with payment, treatment, or operations in direct correlation with a patient, with someone that they're servicing. And then you have the rest of us. Business associates, BAs is the official title of it. So this is anybody that you could possibly doing business with that could remotely, inadvertently, through no fault of their own, have access to that PHI, that protected health information. So those BAs, for example, an IT firm, for example, they're not looking to use that protected health information for anything, but they do have access to it. So we have to make sure that information is 1,000% safe and secure. So that business associate agreement, that BAA, simple piece of paper, even though I've seen hundreds of different types, is basically saying, hey, I'm HIPAA compliant and you're HIPAA compliant, and we're not going to go after each other if something happens. That's the bottom line. But anyone that actually signs that and they're not HIPAA compliant, well, first and foremost, it's willful neglect. So nobody in their right mind would want to go down that road. That's an automatic civil penalty, possible criminal investigation. But how do you ensure that the people you're doing business with are going to do the right thing? Well, you want to vet your vendors. So a simple questionnaire going out to them. For example, my coaches would send out a simple audit questionnaire. It takes them 5 minutes to fill out. Yes or no questions, such as, do you back up your servers? Where do you back up your servers? What type of encryption are you using? You're giving these open-ended questions to make sure that, yes, they actually are encrypted. Yes, they do have backups available. You're probing a little bit just to make sure that they are doing their due diligence, keeping that information safe and secure. Now, granted, you cannot ask them where the servers are located, for example. You're not allowed to ask that. You cannot ask questions such as, well, how many servers do you have? It's a little bit vague, unfortunately, and I'm sure the regulations will change in due time as we become more of a tech-savvy community. But ultimately, you just want to probe a little bit. A simple 5-minute questionnaire, you can find it on our website, for example, compliancygroup.com. You can go to hhs.gov. They have a checklist as well. You just want to, dig a little bit to get them thinking, hey, yeah, I am HIPAA compliant. Or if they're not, they're going to, A, fight you on the business associate agreement and say there's no reason for us to sign it. Or B, they're going to look at their own internal compliance and see how they could up that and make sure that they are doing the right thing so they can actually, A, protect you as the client, and B, garner more clients as well overall.
Mm-hmm. Yeah. So what is the regulation on having to vet out the vendors, and what's the extent of what needs to be done in regards to that in terms of HIPAA law?
Right. In terms of the laws itself of 164.4, what they're looking for is for you to show good faith efforts. They are looking for you to do your due diligence, that not only you have an effective internal HIPAA compliance program, that you are vetting your vendors as well. And the government, it's kind of commonplace at this point. They do understand a breach will occur eventually. It's likely to occur. And the majority of breaches are, 94% of them are actually human error. People click on things, they look at things they're not supposed to. It's life, and policies and procedures written into your internal HIPAA compliance should rectify those issues. But it's if they're almost expecting these things to happen eventually. So they understand that we're human, and they understand that everybody is going to have different types of security depending on the nature of their business. For example, someone working in telehealth, working from home on a MacBook, it's going to be a little bit different security-wise versus somebody working in an office environment of a call center type environment with 100 doctors in one space doing telehealth, for example.
All right, excellent. Yeah, so that explains, ensuring with reasonable effort that the business associate is actually complying with HIPAA. And one thing that I teach that's also important is to make sure that their subcontractors are providing them a business associate agreement. Sometimes that's missed, like if someone's using a practice management program that has integrated other technology from other providers that have access to that metadata or any PHI to have that business associate agreement, such as like a practice management program that's using a video conferencing program.
Yep.
That video conferencing programs providing the business associate agreement, that the whole chain of subcontractors, right, is providing
That's
the business
correct.
associate agreement. Yeah.
Branches of a tree.
Yeah. Now, some of these technology providers, however, will say, oh, well, you don't need a business associate agreement from us because we are a conduit. So HIPAA law has the Conduit Clause that says if technology simply connects two endpoints, two devices, together, but has no access to any PHI, then they are simply a conduit and they don't have to provide a business associate agreement Because again, the whole definition of business associate is an organization entity that provides a service and in doing so has access to PHI.
Correct.
Yeah, but I find that most of them, almost all of them, are inaccurate when they say that because they have access to metadata. And now with Edward Snowden, we know a lot about metadata, the government collecting a lot of metadata, who's connecting to who and when. And so the way that we do that on the internet is through IP addresses. So like video conferencing, chat, texting, all those kind of things. They a lot of times capture what IP address is connecting with what IP address, when, how long, and they store that data, which would put them in that bracket, of a business associate. So that's really kind of tricky to look at. Now the business associate agreement itself, like you said, Kelly, you've seen a lot of them. They vary, they're different. So I know sometimes there's concerns about those business associate agreements. Like some of them say, hey, we hold no liability, it's all on you. Or, most of our services are not covered by this business associate agreement, only this one little piece. Or what is it, Kelly, that is required to be in that business associate agreement? What should people look for?
That's the beauty of it. It should be simple. It should be very, very simple. A business associate agreement does not have to be multiple pages. You're looking at a one-pager, which simply says, we will not go after you. You will not go after us if something goes down the pipe. So if Dr. Smith has an issue and they get caught up in a breach, they're not going to go after Amazon Web Services, for example. And if Amazon Web Services goes down because of something big and bad, they're not going to go after Dr. Smith. It should never be a factor of you take full responsibility. You're going to pay my lawyer fees. Not at all whatsoever. It should be a clean break between the two with no confusion and such.
Yeah. So the longer they are, the more risk of there being something that's not going to work for your organization. Okay. Yeah. And I like that, the agency that regulates HIPAA law, Department of Health and Human Services, I like now on their website, they have a sample business associate agreement.
Yes.
Yeah, which is helpful to refer to. Yeah. So another thing is, HIPAA law has 4 main rules: privacy rule, security rule, breach notification rule, and enforcement rule. So privacy has a lot to do with who has access to patient information.
Correct.
So in terms of that, is it important to find out from the business associate in terms of who's going to have access to patient information? Is everything encrypted so that even their workforce is not able to see any patient data, and who has access to that?
In a perfect world, yes. In a perfect world, everybody, every employee, whether it be a W-2 employee, 1099 employee, volunteer, or intern, should have encryption on all of their devices and not have access to that protected health information in a perfect world. But that business associate agreement is to cover you if the other party, unfortunately, is not doing the right thing. Common sense would say, hey, anybody in the office at any given time just might look at something through no fault of their own. They just might pass by a desk in a doctor's office and see a file, for example. So everyone should be covered under the privacy. Everyone should be trained 100%. When I hear employers tell me, I'm only training half of my staff because the other half doesn't have access to stuff, that draws up a red flag for me. You're working in the same office, for example, or if you're telecommuting, if you're telehealth, people can have access to things while you're on a group chat, things of that nature. So general rule of thumb in my book is just train everyone, make sure everyone is on the same exact page, whether it's the CEO or the janitor. That way there's no confusion at all whatsoever.
Okay, yeah, that helps clarify that, especially in terms of the training. So what you're saying is, hey, you should really ensure that if you're doing business with an organization, a business associate, all the staff should be trained.
Correct.
Yeah. But like an organization like Google, like if Google provides a business associate agreement, I would think that they probably don't train all of their staff on HIPAA.
That is correct. There are completely different departments in completely different buildings in completely different countries that will never, ever, ever have access to that information. So you do have to, give a little bit of leeway there. If it's somebody working in the same office environment, yes, absolutely. If you have your workforce that is all telecommuting, such as in the telehealth industry, yes, they all should be trained accordingly, have the same type of encryption, so on and so forth. But when you have totally different, for example, part of Nabisco, that makes cookies and candies and whatnot, they have R&D, they have research and development, and sometimes they do studies and they have access to PHI, protected health information. So the lab is going to be completely HIPAA compliant as its own separate organization, its own separate business almost. The people in the call centers halfway around the world are not accessing PHI, so they do not have to be HIPAA compliant.
Right. Yeah, that makes sense, certainly. So with the security rule, I think the main three things that we have to ensure with the security rule is ensuring confidentiality, integrity, and availability of all PHI. So the confidentiality piece is, those that should not or are not intended to have PHI don't get it. So you're talking about encryption at rest when data is sitting on servers in a server room. And also in motion when it's being transmitted over the internet.
Exactly.
So ensuring that, and then the on-site security. Does your questionnaire, or do you recommend asking about on-site security, like security alarms and so forth?
Oh gosh, absolutely. There have been recent cases where there have been burglaries. People are breaking in for stuff and they're just ransacking the place. They don't know what they're looking at, and they're stealing computers and they're running out the door with them. So alarm systems are beneficial. They are not a part of the security rule as of yet. I'm sure that will change in due time. It's not mandatory to have a security system in place, but we professionally highly recommend it. And it doesn't have to be anything fancy. It could be just, the Ring, a doorbell, or something that, alarm.com, things of that nature, not only to protect that PHI, but just to protect the business overall. If you're working in a home office, equipment's very, very expensive. So you want to do your due diligence to keep your livelihood at stake.
Yeah, yeah. And then another big one in terms of vetting out vendors is the availability of PHI.
Correct.
So, HIPAA requires that there is a contingency plan. If there's a natural disaster or a virus on servers or something like that, having a contingency plan so that you can get access very readily to critical information. So they should have a contingency plan, and not only just have the contingency plan, but actually test it out.
Yes.
Yeah.
Like a fire drill.
Right. Yeah, like a fire drill. Hey, there's a fire. What do we all do? Well, we know what to do, but let's test it, make sure it works, right?
Reminds me of that episode of The Office. Exactly. But yes, it's once again a factor of the government knows something will happen eventually. So have a plan of action in place, ready to go if something were to occur. That natural disaster occurs, there's a blizzard up here in the Northeast, you can't get into the office for the day or the week or whatever. What's the backup plan? Just for basic business. Who's going to work from home? Who's going to call patients? So on and so forth. But then you deal in bigger things such as ransomware. And ransomware is very scary. You're walking into your office or you're working at home and you open up your laptop and you notice a big X on your screen and it's saying, "Congratulations, you've been attacked by ransomware. Please give us $40,000 in Bitcoin to be delivered within 12 hours. And there's actually a countdown on your computer. And then it actually says in the corner, if you're not familiar with Bitcoin, please call our customer service number, and we will assist you on how to do the transaction.
Wow.
It boggles me. It's as if they have wonderful customer service while they're stealing from you.
Yes.
Well, let's help some honest pirates per se. And this is becoming, it's a huge deal. People think that they cannot be affected by ransomware at all whatsoever. I see it every single day. I see it in the one-man shops, guys and gals working from home or a shared space or a small office. And then you had the state of Texas where 29 counties and counting were attacked by ransomware about 4 months ago, all in one shot. So what do? You have a plan of action in place. You don't panic. the FBI states never, ever, ever pay the ransom. 1 in 4 never get their stuff back. So if everything is encrypted the way it's supposed to be, they're not stealing anything because it's encrypted. They cannot get access to it. They're just trying to scare you to get your money. So you should have what's called an incident plan, an incident and remediation plan, a plan of action ready to go. Okay, Mary is going to call the IT company so they can come in right away and wipe the drives. Jill has all the backups at her house, so she's going to run home and get the flash drives, and that's going to bring us down for a matter of hours versus days, if not weeks. And the cost alone in manpower just to get everything back up and running affect all the people that are affected. They have to be notified if it's a certain amount or more. Plus, you're losing business. You're not able to make appointments. You're not able to take payments. You're not able to see everyone. You know, your reliance on these EMRs and EHRs to run everything, which is great, but it is everything in one space. So if you don't have access to it for any given time, you're like a fish out of water. You know, just as if my phones go down, I cannot work. So I have a backup plan in place ready to go. Cell phone on me all times. Everything gets forwarded just in case that occurs.
Right. Yeah. That painting that picture helps a lot. Really, you know, really makes it very clear. Hey, I really need to be doing this. Right.
You do. You do.
Yeah, definitely. I mean, this is the thing that's important to think about here is that it's not like your own personal information where you can take risks. So, hey, you know, if that happened to my own personal information, that would be horrible. But you know what? I'm going to take the risk anyway because it's a hassle to ensure that I have a contingency plan. But in this situation, you are holding many other people's important information. So they are relying on you, right? So it's a much different situation. Imagine having a crowd of people and announcing to them either, you know, yeah, we have this vulnerability and we're not really doing anything about it, or we have this vulnerability of your information and we are doing this, this, and that, right? Yeah. Yeah, different situations. Excellent. Yeah, so one thing about security is, you know, in order to access a piece of technology that you use for healthcare, one of the ways that you secure it is you have your own individual credentials, your username, your password to log in. Only you have that information. And you need to have a password policy for your organization for HIPAA compliance. And your password management ought to be really smart, right? So having long passwords, you know, different passwords for everything. They should be renewed on a periodical basis and using two-factor authentication. However, people can still possibly get access to the technology. So we have the responsibility of auditing access logs, like looking at all the times the system's been accessed, from where, when, what was accessed. So some technology providers make auditing the access logs really easy. Some of them do it for us, right? They'll send us alerts like, hey, you know, this has been accessed from a new device or from a new location. Did you
Happens on Google all the time. Absolutely.
Yeah, yeah, it's fantastic, isn't it? But a lot of providers don't do that. And so we need to be able to audit those access logs and have easy access to it. Do you want to share anything about in terms of what you've seen there?
It could be very cumbersome, especially if you're not tech savvy. It could be quite cumbersome to say the least. If you have an IT guy or gal that works for you or works with you, that's their responsibility to pull those up and do their due diligence as part of their job description to say, yes, this is us, I don't know where this is coming from, let me trace it, see if I can find it, and hopefully nothing big and bad comes out of it. But for a smaller practice, a one-man shop, as I say, working from home, this could be very, very cumbersome and time-consuming to do overall. So you want to choose platforms where you could easily access this information, AWS, Amazon Web Services, for example. You can go in at any given time, and I would say once every 30 days. Once every 30 days, pull up those logs, take a look and see what's going on so it doesn't build up for months and months. Sure, it might take you a few hours to skim through everything once a month or once every 6 months, sit there for an entire day losing business. So if you keep up on it on a regular basis, don't let it build up too much, and that way if something is happening, you're able to find it in a relatively short amount of time as well.
Yeah, makes sense. And then we also have to conduct a risk analysis of any technology that we're using. So risk analysis is identify what are the possible risks to those things that we have to ensure, which is the confidentiality, integrity, and availability of all PHI.
Right.
And then create a plan to mitigate those risks. And I can tell you, this is one of the things that I do a lot. So I provide consulting for telehealth organizations. So a telehealth organization will say, you know, Ray, we want to provide this particular service, so we need this kind of technology. And I will work to select technology that's going to be a good fit for them and that's going to help them be HIPAA compliant. But then I try to break that technology as much as I can. So I try to find all the things that can possibly go wrong on the clinician's end, on the organization's end, and on the client or patient's end. And I tell you, every single technology that I've evaluated, I always find risks that need, and part of that, the risk management plan is configuring the technology appropriately, only using it in the appropriate way, you know, providing those workflows and policies and procedures for using the technology. And, you know, when technologies provide a business associate agreement, often they say, hey, this business associate agreement only covers these services that we provide. If you're going to do this other thing with our technology, it doesn't cover that. So like an example, secure texting. A lot of secure texting programs, tech providers now also allow clinicians to use standard SMS texting with clients. Well, that is not secure by any stretch of the imagination. So you're really using the technology in a way that's not appropriate for healthcare. So conducting that risk analysis is very important. And I find that technology providers, those that are providing it, right, the technology, they're not necessarily going to come out and say, oh, these are the risks to using our technology. So I find that to be really important. Another thing you can help us with, Kelly, is when looking at technology, you've two different scenarios, really. Well, probably many different scenarios, but you have an individual practitioner using technology just for their own practice. They're the only clinician, right? Or you might have a group practice or a large organization. And there's a difference here because one thing that individual clinicians need to determine is who is the covered entity, who owns the medical records. So if an individual has their own private practice, they're the only clinician, they're the covered entity, right? If they are a covered entity under HIPAA. Yeah, so they have full responsibility over those medical records. Now, if they are an employee of a healthcare organization, the healthcare organization is going to be the covered entity almost always, right? If they are a contract worker, they may or may not be the covered entity. The organization may or may not be the covered entity. Yeah, and that really makes a difference because that determines who's responsible for the HIPAA compliance regarding the patient's information that are being served. You have any things you want to add about that?
I do, because this is coming up more and more. It's becoming commonplace nowadays to hear a sole clinician telehealth working from home, working for a bigger company, you know, coming in as a contractor, for example. Who's responsible? Who is the responsible party for this PHI and these files and whatnot? Is it going to be the sole clinician? And then in that case, if they are responsible, then they also must be 1,000% HIPAA compliant. They need their own compliance program, which is effective for them as a whole. Or is it written in their contract with the parent company that the parent company is going to take ownership of the files, that the parent company is going to take ownership of the PHI, and that the parent company will train this independent contractor / employee on what needs to be done and what not needs to be done. So this is something down to a sentence in a contract can determine who's responsible. There's no set regulations on this at this time. as of yet. I'm sure it will change in the future. But when you're reading a contract before you sign up to become an independent contractor for a telehealth organization, where you're picking your own hours, for example, and you're working only certain days a week, and you might work for 2 different or 3 different organizations, depending on your livelihood and what you choose to do, you have to look at those contracts. And ultimately, if you're able to get in there where it says the parent company is responsible for everything, that's great, because that takes your liability off completely when it comes to HIPAA compliance. But I'm also seeing more and more sole practitioners opting to not let the parent company be responsible. They are actually doing HIPAA compliance on their own. They have the big black binder, or they have everything in the cloud. They have all their policies and procedures, employee training of themselves. They manage their own business associate agreements. And the reason why they choose to do that is due to the fact that they want to own those patients. They want to own those files. So if they choose to move elsewhere in the future, they could actually have those patients go along with them. They have a following, per se. So as for who should be in charge of what, that's entirely up to the sole practitioner. That's entirely up to the independent contractor. If they feel it will benefit them in the future to keep those patients, they'll take care of it on their own.
Yeah. So read your agreements.
Read those contracts. Read those agreements. Read the fine print.
So I know clinicians, behavioral health clinicians, providing online counseling that have run into trouble with this, because what happens is they will be listed as a provider on a online company's list, and they will see clients through that technology platform. I won't mention names, but of these companies. But then when they go to leave, the company will not provide them the medical record. They won't provide that patient's data to the clinician. Now, the clinician's responsible for that data, for that record, right? But the company's not willing to give it to them. That's a real problem. So you want to ensure before getting into business with it's really a technology provider. They're providing the platform, right? That if you are the covered entity, you have full control and access to your patient's data, and that it's not going to be too difficult to export that data.
Correct.
Yeah. Now, in terms of when there's a group practice organization, individual clinicians can use their own devices. The organization would want to have a bring your own device policy and procedure. And they could use technology for managing devices, mobile device management systems, where they set those policies for those devices. And that's pretty clear. And then there's bring your own service, where, say, the individual clinician will want to use their own services, like their own cellular service or their own email service, and get emails to their own email service, right? And that runs into problems for the organization, the covered entity, because the covered entity is responsible to have access and manage and secure and vet out all of those service providers that are managing or having access to that PHI. So that could become problematic. So choosing the services being used, and even the devices, that the covered entity, really, we have to identify who is that covered entity, and then the covered entity really has to take responsibility for that.
Exactly.
Yeah. Any further thoughts on that, Kelly?
If you're looking to own your stuff, if you're looking to be your own covered entity, and it states it clearly in your contract, you have to understand the risks that you are taking associated with such. You have to make sure that you are going to protect this PHI, protected health information, with every inch of your fiber and being. Now, granted, laptops get stolen, cell phones get lost, things of that nature. But once again, if those simple steps, precautions are taken, the encryption on your cell phone, for example, for us, we use a program called Knox, which has a totally different email. It has a totally different folder. It looks exactly the same as my regular Google account, but it separates everything completely. So if my cell phone is lost, for example, sure, they're able to get into my Facebook. They're able to get into my Instagram or my personal emails, but they'll never get into my work stuff. at all whatsoever, because we took the responsibility to make sure. And if you're going on your own doing that, you have to do the exact same thing. Know your risks and think long and hard before you decide, hey, I'll do it on my own, or I'm going to go under the parent company and let them cover me.
Sure. Yep. Yep. And that's one of the things that my organization provides is if an organization's wanting to bring your own devices or wanting to manage devices or manage browsers or manage users on a platform, that's something that we set up. And those services are fantastic. They're really amazing with all the configurations and security levels, and they're very, very helpful. So another thing to look at with choosing technology is where is the data? Because we want to make sure that the data is not lost. So data retention policies is really important. So say you're using a video conferencing program. So right now, Kelly and I are on video conferencing together. If we wanted, we can send chat messages back and forth to each other. Well, if I'm the clinician, Kelly's my client, we're sending chat messages back and forth. That's clinical information in electronic form. So I have to retain that data. Is that right, Kelly?
That is correct. That is correct. Just like an old school patient file, it has to be retained no matter what platform it's brought up against, whether it's electronic, whether it's paper, or a combination of two in some offices, whether you're doing a telehealth seminar or whether you're face-to-face, all that information must be stored.
So would a healthcare organization be able to state in their policy on their designated record set that, you know what, text messages or chat messages sent during a encounter are not part of our designated record set, therefore they don't have to retain them?
No, they really, really do need to retain them. No matter what anyone says, it is actually PHI. It is patient information, protected health information. And no matter what you say or no matter what you do, there's really no way around that at this moment. Granted, there might be maybe Zoom will not have a chat function in the future. Maybe they'll have something else entirely different, whole other program to work with, add it to the list of the ones we already have, and then you might be able to get away with something on that. But why chance it? Why chance it? Just do what you're supposed to do, follow the laws, and you keep your nose clean. You're perfectly fine.
And in terms of that data retention, how long you have to retain it is dependent on the state laws, not HIPAA.
It is. Yeah. Well, yes and no, because it's funny you mentioned that California is going for 10 years retention at this point, so is Texas. They're the strictest in the nation. State law will always trump federal, but federal laws always seem to follow right behind. So if a state does something different, for example, HB 300 in Texas years ago, you better believe that HHS is going to go back and do the same exact thing a year or two later. So always follow your state laws first.
Yeah. Okay. Yeah. So you have to find out from the technology provider, again, what data is stored and what data is not stored. So there's data is either stored locally on your device or it's stored on the technology provider's servers. So like you mentioned, we're using Zoom right now, Kelly. If I have a business associate agreement with Zoom, as of today, Zoom will not retain those chat messages with the business associate agreement, which means they will be lost when I close out of this meeting. So I would have to have a policy to ensure that clinicians save that chat if that chat's going to be enabled and used. So it's just really understanding where is data and what are the risks to being lost. And so according to that, what are the policies and how is it that you want to configure the technology? Another thing is be able to export your data. So say you stop using a technology provider, you want to start using a new one. How is it that you're going to be able to export the data? How easy is that? I love working with technology providers where they say, you know what, you can stop using us whenever you want, and we will provide you a file, a folder with individual files for each client with all of their data and PDFs, and it's all there, right? Yeah, I love that. So that's a good technology provider to use where you'd be able to do that. Not one where you're going to be stuck or you're going to be having to do a lot of work to get your data or keep paying money each month so for them to retain the records.
Holding your data hostage. Exactly, which is big and bad because by HIPAA regulations, you must have 6 years worth of documentation under your belts for anybody that asks for that information. So if you're not able to access that for quite a while and something happens, you're in violation. And then you have to prove to OCR that you are doing your due diligence to at least try to get this information back. But once again, written in the contract, it should say if your contract ceases that you have 30 days to get your stuff off the servers, for example, or that the provider is going to actually give you your information back, or at least work something out in between.
Thank you. Yeah, and then the breach notification rule. In terms of how vendors, business associates ought to provide breach notification to the covered entity and what the responsibility is, do they have to be the ones to report to HHS? And can you explain that a little bit in terms of business associates and breach notification?
Absolutely. So if the breach or the incident or whatever it may be occurs in your house, you are responsible for taking care of it. You are responsible for reporting to OCR. You are responsible for reaching out to every company that you work with. You are responsible for notifying your patients depending on how many people are affected. So rule of thumb is if it started with you, you have to take care of it 1,000%. If my doctor goes through a breach, LabCorp, if LabCorp goes through another breach, for example, it's not my responsibility as a doctor to take care of LabCorp's problem. That's the simplest way we could state it. So long story short, if it's yours, own it. Make sure it's taken care of in a timely manner. Once again, and just a quick note here, if you have any incidents that 500 people or less were affected, it must be reported by February 29th of this year. Otherwise, you're not in compliance and something big and bad can happen.
Is it February 29th of every year?
No, of course not. Absolutely not. Rule of thumb is 60 days from the last day of the calendar year. So December 31st plus 60 is giving us our February 29th, March 1st day.
Okay, all right, got it. Yeah, 60 days from the last day of the year, you said?
Correct.
Yeah, okay,
Correct.
Interesting. Yeah, so the last thing I would say is in terms of selecting a vendor is choosing one that's going to be sustainable, that's reliable, that you can trust. Small companies, I want to support small companies. However, you want to be careful that it's not going to be a fly-by-night company. You want to make sure that they actually have the money, the funding, the staff, the technology, that they're going to stick around, that they're constantly improving and, patching security issues and so forth. So I would certainly, take a look at that and use a consultant, someone that knows about this technology, knows how to check it out, that's in the field to give you guidance on selecting the vendor.
Exactly. I actually, consultants I compare to travel agents. You want this done, it takes a lot of work to put into it, but you don't have the time or the effort to do so. You hire somebody to do that on your behalf.
Yeah. In terms of hiring someone to do it on your behalf, Compliancy Group, everyone, they will handhold you through the process of becoming HIPAA compliant. Becoming HIPAA compliant is really a very difficult task. I would like to be able to say, oh, you can do it, and it's not so bad. Well, I have to be honest, HIPAA compliance is very confusing, and it's quite a task to do on your own. You really have to be a HIPAA expert, right? So why try to do that? I think companies like Compliancy Group, hand-holding you through the process of becoming HIPAA compliant is the way to go. And I can say from my experience, Compliancy Group does a great job. We have an affiliate agreement with Compliancy Group, and we also have a discount that we provide for those that sign up with Compliancy Group. We'll add that link. So hopefully this has been beneficial to you watching. And again, if you need any assistance, just reach out to us. And
Please.
Now you know how it is to really vet out the business associates that you're going to do business with.
Absolutely. Any questions, any concerns? No silly questions here at HIPAA. Feel free to reach out. It's what we're here for.
Yeah, thanks a lot, Kelly.
Thank you. Have a great day.
You too.